Good morning, everybody. Welcome to Law Minds. Today, we'll be talking about the topic the opinion of third persons. So, this is stated in Article 45 to 51 of the Indian Evidence Act. Now, what does Article 45 say? So, it talks about opinion of experts. So, according to Article 45, when the court has to form an opinion upon a point of foreign law, science, art, or it has to identify a handwriting or maybe a finger or maybe finger impressions. So in these cases, the opinion upon that point of persons specially skilled in such foreign law, science or art, they are relevant facts for the case. So let's understand it by the help of illustrations. So for example, A died by poison. So, in this case, the opinion of experts as to the symptoms produced by the poison by which A is supposed to have died are relevant. Now, let's talk about the next example. So, in the next example, the question is that whether A, at the time of doing a certain act, by reason of unsoundness of mind, incapable of knowing the nature of the act, or that what he was doing was either wrong or it was contrary to law. So he was unaware of the nature of whatever he was doing. So in this example, the opinion of experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind, and whether such unsoundness of mind usually renders persons incapable of knowing the nature of the act which they do, or of knowing that what they do is either wrong or contrary to law, are relevant. Now, the third example, so the question is whether a certain document was written by A or not. So, in this case, the opinion of experts on the question whether the two documents were written by the same person or by different persons are relevant. Okay, so whoever is acquainted with the person's handwriting or a handwriting expert is, their opinion is relevant in these questions. Now let's talk about the section 41A. So it talks about opinion of examiner of electronic evidence. Okay, so according to this section, when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, then the opinion of examiner of electronic evidence referred to in section 79A of the IT Act, Information Technology Act 2000 is a relevant fact, right? So opinion of the examiner of electronic evidence examiner of electronic evidence as referred to in section 79A of IT Act 2000. So this is a relevant fact for the case. Now let's come down to section 46. So it talks about facts bearing upon opinion of experts. So now section 46 tells us that facts which are not otherwise relevant are relevant if they support or are inconsistent with the opinion of experts, which when such opinions are relevant. So now it may sound very confusing, but let's understand it. So this section basically tells us that when the opinion of a certain expert is relevant, then the facts on which this opinion is based, they are also relevant. Now it does not matter if the facts on which this opinion was based are relevant for the case or not. Okay, so that's what's stated. Facts not otherwise relevant are relevant if they support or do not support opinion of experts when the opinion in itself is relevant. Okay, now again let's take help of certain illustrations. So the first one, A was poisoned by a certain poison. Now the fact that other persons who were poisoned by that poison exhibited certain symptoms which experts affirm or deny to be the symptoms of that poison is relevant. Okay, that is relevant. Now the second example is whether obstruction to a harbor is caused by a certain sea route. So, if this is the question, then the fact that other harbors similarly situated in other respects, but where there was no such sea walls, began to be obstructed at about the same time is relevant. Okay. Now let's talk about section 47. So it talks about opinion as to handwriting when relevant. Okay. So according to this section, when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed or was not written or signed by that person is a relevant fact. Okay, so while this again may seem very confusing, so iska basically it means that if the court has to decide whether this person wrote a document or signed it, then a person who is acquainted with that person's handwriting, this person's opinion, the person who is acquainted with the handwriting, this person's opinion is a relevant fact. Okay, so if I know how my friend writes, and if I'm acquainted, if I've seen the documents, we'll talk about that later in this video. So if the court has to determine whether my friend really wrote this document, then if I am in the position to determine my friend's handwriting, then my opinion is a relevant fact. Now, what is the criteria? We'll talk about it later. So, yes, a person acquainted with the handwriting, that is a relevant fact. Now, again, let's understand it with the help of illustrations. So, if I have a friend A, right, then if I know this person for a very long time, now by long time, like, that is a fact. But the thing is, if I'm acquainted with this person's handwriting, okay, so we started together, we have been in constant touch, and I can establish that yes, these are the documents or these are the letters or whatever that he wrote to me, and I am, in a position to know, in a position to identify whether A has written something or not, even though I have not seen him write. Okay, but I very well identify his handwriting, right? So if I'm able to establish that, then my opinion will be relevant in a case where the court has to determine whether A wrote or signed a particular document. Okay, so yes, now let's talk about section 47A. So it talks about opinion as to digital signature when relevant. So according to section 47A, when the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is a relevant fact. Okay, so according to this section, if the court has to determine something about the digital signature, the validity, the authenticity of a digital signature, then the person who is the certifying authority which has issued the electronic signature certificate, that is a so that person's opinion is a relevant fact. Okay, certifying authority's opinion is a relevant fact. Okay, which whoever has issued the electronic signature certificate. Now let's talk about section 48. So section 48 tells us about the opinion as to existence of right or custom when relevant. Okay, so when the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of person who would be likely to know of its existence if it existed are relevant. Okay, so a person who is likely to know about these customs, or if they existed, or this person lives there, has lived there for a sufficient amount of time to determine the existence of these customs, so this person's opinion is a relevant fact. Okay, so let's talk about illustrations. So if we say that there's this, I'm sorry, yeah. So if we say there's this well in a village, right? Let's say in village A, and village B also uses this well. Okay, so this is the alleged, this is the alleged custom, okay, or existence of right. So if the court has to determine whether village B has been using the well of village A, or is there a custom or is there a right, then the villagers who have lived there for a sufficient amount of time, so their opinion will be a fact. Okay, because they are capable of determining this issue. They're capable of telling whether this thing existed or is it or not. Okay, so that's this illustration. Now let's talk about section 49. So 49 tells us the opinion as to usages, tenets, etc. when relevant. Okay, so according to section 49, when the court has to form an opinion as to the usages and tenets of any body of men or family, the constitution and government of any religious or charitable foundation, right, or any religious or charitable foundation, or meaning of words or terms used in particular districts or particular, classes of people, then when these type of issues are to be determined by the court, then opinions of persons having special means of knowledge are relevant. Okay, now let's talk about section 50. So section 50 talks about opinion on relationship when relevant. So according to this section, when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such I'm sorry, one sec. Yes, then the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact. Okay, so then basically the member of a family or a person who has special means of knowledge on the subject, so this person's opinion is a relevant fact. So now there are certain exceptions, that it is not sufficient to prove a marriage, okay, under Indian Divorce Act 1869, or in prosecutions under sections 494, 495, 497, 498 of the Indian Penal Code 1860, right? So let's talk about illustrations. So if the court has to determine whether A and B are married, then basically the fact that they were still received, if they were usually received and treated by their friends as husband and wife, is relevant. Okay, so because we kind of assume that friends are acquainted with their daily affairs, so they must be aware of the relationship. Okay, So they come under this, that they have special means of knowledge here, special means of knowledge on the subject. Okay, now let's proceed. So yes, so whether A and B are married. Now the next example is whether A is the legitimate son of B. So in this case, the fact that A was always treated as such by members of the family is relevant. Okay, so members of the family fall under again this group. 1 second. Yeah, so they again fall under people who have special means of knowledge on the subject. Okay, so that's that. Now let's talk about section 51, which talks about grounds of opinion when relevant. Okay, so whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. Okay, so if this living person, this person has formed an opinion, then in order for it to be relevant, I mean, whenever the opinion is relevant, then the grounds on which it is based are also relevant. Okay, so for example, let's again take help of certain illustrations. So if the expert has given the opinion on a certain topic, so let's take example on the poisoning of A. Okay, poisoning of A. So whether A was poisoned using a particular poison or not. So if the expert has said yes, A was poisoned using this particular poison only, then this expert also has to show the grounds on which he has formed that opinion. So for example, he has to show that this is the general reaction of people when they consume this poison. Okay, so the experiments performed or whatever data, whatever grounds on which the opinion is based also have to be very clear. Okay, so that was about it. Thank you for your kind attention, and that's it for this video. Keep learning, and please like, subscribe this channel for further legal content. Thank you so much.